Assalamualaikum warahmatullahi wabarakatuh. Hello everyone. I hope you are in good condition and happy situation. Before we begin our presentations, let me introduce myself. My name is MUHAMAD RIDWAN. I am from the Group 1. Now, I, as a first speaker, in this beautiful time, we would like to talk to you about certain topic relating to the criminal law, such as analyze the defense of mistake under the Malaysian Penal Code and how is the applications of the defense of mistake under Islamic criminal law. I will begin by explaining the introduction. Ladies and gentlemen, jurists define mistake as appearance of a thing without intentions of the door. That is to say, the person committing the crime wrongfully is not malicious or willing, which is distinct from the person committing the crime purposely. Look at the picture. Based on this principle or maxim, sentencing requires both actus reus or guilty act and mens rea, guilty mind. In this case, mens rea refers to the state of mind expressly or impliedly required by the definitions of the offense charged. Next. And then, in this slide, there are two forms of defense of mistake under Malaysian Penal Code and under Islamic criminal law. For the first one, based on Malaysian Penal Code, defense of mistake is a part of general defense for criminal liability in Chapter 4 of the Penal Code. There are two forms of mistake considered by criminal law in defense of mistake, such as mistake of fact and mistake of law. Let's say a convicted suspect may choose in certain cases to argue that the criminal perpetrator never decided to commit a crime and that the crime happened as a result of mistake of fact or misconceptions of a crime at the time. And the other one, based on Sharia law or Islamic criminal law, mistake is a defense mechanism which liberates an individual from criminal liability in Islamic law. Through Holy Book Al-Quran, Allah says in Surah Al-Ahzab, verse 5, which means, and there is no sins against you if you are mistaken about it, but what is your heart will do. Allah is forgiving, most merciful. The next part will be delivered by my friend.
Good morning, madam. My name is Lim Junni, metric number 272913. I am going to present about defense of mistake under Malaysian Penal Code. In Malaysia, defense of mistake has been stated under section 76 and 79. The wordings in these two sections shows that nothing is an offense. It refers to the defense of mistake is applied to all criminal offenses, except is excluded by the statute. To raise defense of mistake under Malaysia Penal Code, there are three elements that need to be fulfilled. First, the mistake is a mistake of fact. Second, the accused must done in good faith. And third, the mistake done is not a mistake of law. Section 52 defines good faith as if a person is honest in his intention, he is expected to act with due care and caution. This element is illustrated in the case of public prosecutor against Teo Eng Chan. In this case, the accused raised the defense of mistake as they presume the victim was consented to have sexual intercourse with them. But due to the lack of care and caution, the court rejected the defense. Besides, the accused must prove that he has reasonable ground to believe that it is what he ought to do. In the case of Chiragi against State, the appellant killed his son as he mistakenly believed him to be a tiger, but he was able to prove that his physical disability had caused him to do this act. Thus, this shows that he was acting in good faith and defense of mistake is accepted. Defense of mistake under Malaysia Penal Code highlighted bound by law and justified by law. Bound by law is mentioned in section 76. It applies to the situation where the accused, such as the police or the soldier, has the legal obligation to obey the superior order in carrying out the conduct which he is being sued. The order can be categorized as lawful order and unlawful order. Lawful order means the command of the superior which is lawful and justified. This can be seen in the case of State of West Bengal. The court held that the obeyer of the lawful order will be fully protected under this defense, while if the order is unlawful, the court has to examine whether the accused know the order is unlawful. In this situation, only the accused act in belief that the order was lawful, he will be protected under this defense. Next is justified by law, which is mentioned under section 79. It refers to the accused act which is not illegal. It can be seen in the case of R against Towson, where the appellant believed that her husband has died, so she remarried. But in reality, his husband was still alive, so she was charged for bigamy. But the court allowed the defense of mistake because she was justified by law and believed in good faith that her husband was died. So I will pass my floor to my teammate. Thank you.
Moving on, the third element is it must not a mistake of law. A mistake of law takes place when one has full knowledge of the facts but result in an erroneous conclusion, is expressly excluded by Section 76 and 79 of Penal Code. Thus, it is not a defense. Meanwhile, mistake of law is not equivalent to ignorance of law. Ignorance infers a total want of knowledge, whereas mistake admits such knowledge but implies an erroneous conclusions. Basically, it's classified into two categories. First, ignorance as to the assistant or non-assistant of law, which means that the person claims that he doesn't know the law when he is guilty of an offense. There's a Latin maxim called ignorantius juris non excusa, which means that ignorance of law is not excuse. In this case, the court held that not familiar with the law of application process for foreign worker pass does not provide a defense. However, there's an exception if person could not reasonably know the assistant or not assistant of the law. In this case, the accused were charged with importing pianos from South Africa. It provides a defense as accused can prove on a balance of probabilities that he could not reasonably know the prohibitions. Secondly, mistake as to interpretation of the law, which is misconceptions. This mistaken belief arises from a process of reasoning based on facts lead to an erroneous conclusions. In this case, the first accused was charged with corruptions. He contended that he acted in accordance with the provision of municipal ordinance. However, the court held that this is a mistake of law, which is excluded from Section 76. In the last case, the court held that the misconception of law relating to his legal power in enforcing the contract is not a defense. To sum up, mistake of law is generally not a defense in Malaysia. Overall, in order to raise the defense of mistake in Malaysia, it should be mistake of fact, it must be done in good faith, and it must not a mistake of law.
Assalamualaikum, a very good afternoon to Madam and fellow group members. So, my name is INANI binti MUHAMAD ZULKIFLI, and I will be presenting about the division of mistake in Islamic criminal offences in Malaysia. So, as we all know, religion is a sensitive issue, especially in a multiracial country like Malaysia, where it can easily trigger a chaotic situation if one belittle other people's faith or belief. So, in Islamic or Sharia law, the jurists characterize a mistake as an event of a thing without deliberate or practitioner, which to simplify that the individual commits the wrongdoing without purposeful or need. Okay, so moving on to the division of mistake in Islamic criminal offences, which we have two here. For the first division is generated and ungenerated mistake. And for the second division, we have specific and non-specific mistake. Okay, so what is meant by generated mistake is where one that generated from lawful act or the doer did it believing that the act is lawful direct. And for the ungenerated mistake, it may emerge straightforwardly from the individual who makes mistake without any implies. So in accordance to Sharia Criminal Offence Enactment, Section 61, nothing is an offence which is done by a person who is justified by law or who by reason of mistake of fact and not by reason of mistake of law in good faith believed himself to be justified by law in doing so. So this is for the generated and ungenerated mistake. Okay, moving on to the specific and non-specific mistake. Okay, according to Maliki and Hanbali School of Law, they believe that the doer are liable for criminal offences due to the blameworthy mind of the doer. Okay, so let's see the example. Okay, a person where he points to kill a particular person and the bullet went to kill a diverse individual, which fall under the specific mistake. And when an individual point to kill A but kill someone else that look like A, which fall under the non-specific mistake. So we can see here that the doer has the intention to kill other person. However, different story can be said if the act done was at first legal. At that point, mistake can have the effect on the result of the act. Okay, this is for the specific and non-specific mistake. Okay, moving on to the provision available in Malaysia, where Islamic law in Malaysia only confined to personal law, and it is differ from one state to another. For example, Section 50 of Sharia Criminal Offences Act 1997, which is under the federal territorial jurisdiction. And then another example can be seen here, Section 4 under the Syariah Negeri Sembilan Enactment 1997. But then, the similarities of the provision, defense of mistake can be raised to the extent, first, act done by the accused was of good faith, second, believe that his act will be justified by law, and third, dismisses the acknowledgement of the mistake of law as factor to raise this defense. So, this is all for my part. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nasrin Nabihah binti Zuperi and my metric number is 272244. So for my part, I'm going to explain on the analysis of remedies under Islamic criminal law in terms of defense of mistake. So in this analysis, we'll be comparing between Sharia Criminal Offences Act and also Islamic criminal law. So for the first element is in terms of their application. So in Sharia Criminal Offences Act, the application is under the provision of Section 50 of the Sharia Criminal Offences Act. So in Section 50 of the Sharia Criminal Offences Act, it says that nothing is an offence when it is done in relation to a mistake of fact, not a mistake of law, and the person believes in good faith that he is justified by the law when he committed the act. While in Islamic criminal law, the applications of defense of mistake actually depends on different interpretations of juries and the acceptances under various schools of thoughts. And the second element is its general view. So for the general view, basically Sharia Criminal Offences Act's general view is in accordance to Islamic criminal law general view. So in Islamic criminal law, its general view is that the doer could plead defense of mistake upon believing that he will be justified by the law. While on the other hand, for Sharia Criminal Offences Act, its general view is that the doer can plead defense of mistake if the act itself was carried out without having the means of carrying out the offences stated under the Sharia Criminal Offences Act itself. So the last one, in terms of their legislation. So in Sharia Criminal Offences Act, it is no doubt that this legislation is a written legislation, which in Malaysia, its relevancy has been already signified. While in Islamic criminal law, it is not a written legislation, and its enforcement must be in accordance with the Sunni school of thought and also from the views of Shafi'i jurists. That's all.
Assalamualaikum, Madam. I am ILIEYEENNUR and I will be presenting on the comparison of the defense of mistake under Malaysian Penal Code and Islamic criminal law. So let's look at the comparison aspects. First, we will compare on the mistake of fact, next, mistake of law, next, good faith and proper care, court jurisdictions, parties to the suits, and lastly, interpretations. So, in respects to mistake of fact, the Malaysian Penal Code states that nothing is an offence which is done by a person who is or who, by reason of mistake of fact and not by mistake of law, in good faith believes that himself to be, in accordance to section 76 of the Penal Code, bound by law to do it, and according to section 79 of the Penal Code, he believes that he is justified by the law in doing it. In accordance to Islamic criminal law, it is clearly stated that nothing is an offence when it is done in the relation to a mistake of fact and not a mistake of law, and the person believes in good faith that he is justified by the law to do it when he commits the act. So the difference between this is that the word bound by law, which is stated under the Malaysian Penal Code, is not expressly mentioned in the Islamic criminal law. Next, in respects to mistake of law, in both the Malaysian Penal Code and Islamic criminal law, mistake of law is not considered as a valid reason of defense of mistake. In the Malaysian Penal Code, there is a legal maxim that states that ignorantia juris non excusat, which means that ignorance of the law is not an excuse. Next, in observing the defense of mistake, good faith and proper care, in accordance to Malaysian Penal Code section 52, it states that a person is expected to act with due care and caution in committing the act, in order to plead for defense under mistake under mistake. Next, Islamic criminal law. Under Islamic criminal law, a defense of mistake may be pleaded by the person who believes in good faith that he is justified by the law when he commits the act, and in accordance to ungenerated mistake, a person is not liable only if it is not possible for him to have taken proper care against the action. Good faith is an important element in invoking the defense of mistake in both statutes. Next, in accordance to the court jurisdiction. The Malaysian Penal Code may apply to all courts as the magistrate court, the session courts, the high courts, appeal courts, and federal courts. And in according to Islamic criminal law, it can only be applied in Sharia Sharia courts. Parties to the suit, in accordance for the Penal Code to apply, both parties can be either Muslim or non-Muslim. However, in accordance to Islamic criminal law, it can only apply when both parties are Muslims or of Islamic religion. Next, lastly, the interpretation. In Malaysian Penal Code, all interpretation is made based on one source of law and applied across the country. However, Islamic criminal law, it may differ from one place to another because the interpretation of the defense on the grounds of mistake differs according to the different Muslim jurists of Islamic school of thought. Also, the written law may differ from one state to another according to the state legislations. That is all from me of the comparison between the Malaysian Penal Code and Islamic criminal law of the defense of mistake.
Hello ladies and gentlemen, it's me, RIDWAN again. In this part, at the end of presentations, we would like to review the key points from these sessions and wrap up. Let's remind ourselves of why this should matter to everyone in here. Starting from conclusions, let's see the picture. Defense of mistake of fact may be raised in a wide range of illegal acts but differs from mistake of law. Secondly, can be raised in accordance with circumstance mentioned in each provision, especially section 76 and 79 of Malaysian Penal Code. The distinction between the two provisions is that the wording of bound by law and justified by law. And the last one, we conclude that in Islamic criminal law emphasize that a person cannot be found guilty unless his intention to commit such offense is proven. Ladies and gentlemen, beside of conclusions, after we analyze, we got several recommendations in order to improve our existing law. For the first one, the court need to thoroughly differentiate between both types of mistake because this is crucial as prosecution has to prove beyond a reasonable doubt that the accused was not mistaken while in the present situations. Then the accused must prove the defense of mistake on a balanced probabilities. And secondly, additional of one provisions into section 79 because its necessity is proven in order to prevent the operations of said provisions that deny the defense of a person who believe that they committed a less serious offense than the one who actually committed in a good faith. This is concerning a strict applications of section 79 will result in a person to be denied of the defense when in fact the accused believe that they are committing different and less serious crime. And the last one, additional of one specific provisions to make a clear line between two types of mistake because considering how difficult it is to distinguish the concept between these two types of defense of mistake. So, in order to do so, a possible model of framework could serve as reference, which is the Australian Commonwealth Criminal Code 1995. In this statutory, there is a provision that distinguishes mistake of fact and ignorance of law. Therefore, court will have crystal clear interpretations in the process of the judgment if these new provisions were to be added in the Malaysian Penal Code. Ladies and gentlemen, that's all from us. I hope you are all understand and your attentions it's mean a world for us. Wassalamualaikum warahmatullahi wabarakatuh.